Hello everyone, this is Advocate Pawan here. So today we'll be learning about all the important judgments required for your exam perspective. Starting from February, we will be covering it up. All the important judgments. Please do listen carefully because these questions have been curated out of a lot of effort and hard work. And you have to listen and learn because for your upcoming exam, surely they can ask such kind of questions too. So now let's get started without any further delay. Three, two, one. So take down your notes, start writing down. Okay, I'll just go with the scenario first, then I'll be explaining you the concepts and what kind of questions they can ask me. So, based on every month, I've basically curated the content, and don't worry about the notes, whatever it's required. At the last, I'll be announcing for it. Let's start. The police arrest Kamal, but tell his brother the reason. Okay, police is basically arresting Kamal and tell his brother the reason. The judge says that's unconstitutional. Kamal himself must know why he is being arrested. Okay, remember. So, if a police is arresting, he is going and informing the police my relatives is great, but you have to come and tell me first. That is very important. So let's see the question. Okay, under Article 22 clause 1 of the Indian Constitution, what constitutes proper compliance with the requirement to inform an arrested person of the ground of their arrest is what? Option C, the personally and effectively communicating the grounds of arrest to the arrestee is very important. This was decided in which case? In the Vihan Kumar versus the state of Haryana and ANR case. Very important case. Please to learn the case name along with the notes. The Supreme Court clarified that informing the relatives or recording reasons in official documents does not fully fulfill the Article 22 clause 1. The arrestee must be personally informed in all and effective terms about the grounds of arrest. So in Article 22 clearly clause 1 clearly says that you have to inform the other person on what grounds you have been arresting them. Okay, second question. Okay, second question, what is it? So decide when a repealing act is not required to obtain fresh presidential assent under Article 254 of the Constitution. So what is this? So I'll just look at the example first, then I'll be telling you. The Karnataka repeals a law to fix small errors. The judge says no need for fresh assent. You are not rewriting the law, just refining it. Okay, let me just go to the question now. Decide whether a repealing act is not required to obtain fresh presidential assent under Article 254 of the Constitution. B, when the repealing act is intended to correct the flaws in the old law without contradicting prior judicial rulings. So the repealing act does not need fresh presidential assent. So remember carefully, if there is any new law, if it's introduced, then you need to take precedence assent. Now, what about an old law? If I'm trying to repeal it, make few couple of changes, okay, because there were a couple of flaws into it. So what do you think about it? So it is not a what not in, as it is not a new kind of law, this one you did not take the presidential lesson. It was taken in which case? SRS Travels by proprietor KT Rajashekharan versus the KSRTC workers and ORS case. Now, the third question. Let's deal with the third question. Okay. So, Kamal marries Pawan's cousin knowing she was separated, not divorced. Later, refuses maintenance. Court says, you can't escape. You accepted her as your wife. Very simple. So, if Kamal is marrying my cousin, okay, and she was basically separated but not divorced, but after later date what happens? If there is a if Kamal basically, there's a fight between me, Kamal and my cousin, and he was willing to separate, and he'll tell that no, I married you when she was separated, not divorced. So can he escape from maintenance? No, he cannot escape from maintenance. He have to pay the full amount for it. You can't escape because you accepted her as your wife. Very important. Let's look at the question now. A woman, without obtaining a formal divorce from her first husband, marries a second time with a man who is fully aware of her first marriage. They live together, have a child, and later separate due to disputes. The woman seeks maintenance under Section 125 of the CRPC from her second husband. The second husband opposes the claim, arguing that she is not legally his wife, as her first marriage was never legally dissolved. See how smart people are. Decide whether the woman can claim maintenance under Section 125 of the CRPC from the second husband. The answer is what? It is the answer B. The answer is the woman is entitled to maintenance since her second husband knew about her first marriage and lived with her as her husband and wife. Very important. So please do learn this case. And Usha Rani versus the Modula Srinivas case. Now, fourth question. Okay. Fourth question. The Pawan cancels the flat booking. Builder deducts 20%. Court says cut it to 10%. Beyond that, it's punishment, not earnest money. So if there is a deduction, it cannot be for 20%. It should always be for 10%. So the Supreme Court held that forfeiture under Section 74 must be reasonable. 10% is acceptable, but 20% is excessive and penal. Forfeiture should be securing performance, not punishing under the breach. So, which is the famous name? Godrej Projects Development versus the Anil Karlekar case. Very important case. Please do learn it. Okay. Now, the fifth question. The Kamal files direct FIR plea. Okay, Kamal is basically filing what? A direct FIR plea. The Pawan judge says, brings affidavit, shows SP's response, then I will see if the enquiry needed or not. Very simple. For example, if Kamal is filing that FIR directly, okay, the judge says you bring an affidavit of the SP, then only I will be accepting it. So it's a new kind of procedure which they should be following it. The BNSS codifies three safeguards. The first one is what? Affidavit and SP copy. Second is judicial inquiry. Third is about evaluation of the refusal. These prevent the misuse of section 156 of the powers. Very simple. Under the BNSS, what safeguard exists before magistrate can direct FIR registration under section 15, 175 clause 3? It is D. That is, the complaint must be file affidavit, send a copy to the SP. Then is about what? Magistrate must hold preliminary inquiry and magistrate must consider police refusal reasons. So these are the three grounds. Only if they consider, you can proceed further. Okay, remember. Now, next question before that. Pawan abuses Kamal in a private office. No one else around. Kamal's court says, no public view, SC/ST provisions don't apply. If the if I'm basically abusing someone of who is an SC/ST person in a private room, but not in public, can I be held liable? No, because there's no kind of evidences. That's the first thing. Okay, this was decided in which case? Karupudiyar versus the state. Okay, the section 3 clause 1R and SCST Act to apply. Abuse must occur in the public view. The private insults inside closed chambers does not qualify it. So what is the case? Incidents occurs in the officer's private chamber where the accused uses castle clerks. Can SCST apply? The answer is D. No, because no one was present in the private space. Two is about what? Abuse in private does not qualify as a public view. I hope that's very clear for you. Now, seventh question. Kamal doubt child's paternity. Okay. Kamal is basically doubting the child's paternity. Pawan Judge says, unless you prove zero access, law presumes the child is yours. Okay. So if Kamal is having doubt that whether the child belongs to him or not. So I am the judge. I am saying that unless you prove that there is a zero access, or you can prove in any other way, the child will always be yours. Until that means through DNA or any other particular way. If you don't prove it, then you cannot be you cannot say that that's not your child. Ex suspect his wife's child is not his due to a affair. Can he build a paternity presumption? So it is basically only if he proves no access during the conception. So he should be proving that. See, DNA and all, no, you cannot take it directly. There's a lot of procedures for it. Okay, so that you just need to keep in the mind. Now, eighth question. Pawan buys property mid-case. Kamal wins the degree. Court says, Pawan, you are bound. You bought during the litigation. Okay, very simple. X sells the property to Z. While Y's specific performance suit is pending. Z's impleaded denied. Okay, can Z appeal the decree? Answer is C. No, bound under section 52 of the TPA Act. So very simple. During a pendency case, okay, during a pending case, if I'm buying a particular property, so if court is asking to return that particular property, I have to return it because I'm bound by the decree of the court. Okay. Now, ninth question is what? Kamal says, knife in the garden. Police find it. No other proof. The court says disclosure alone can't prove guilty. Just because you found something, the court cannot what police cannot blame you around. Okay. So Vinod Bhai versus the state of Kerala. What happened in this case? A disclosure statement alone is a weak form of evidences. Insufficient without corroboration to sustain the conviction is very important. So remember carefully. The police recovers a murder weapon based only on the accused disclosure. No other proof. Is it enough for proving that the conviction is valid? The answer is no. No needs corroboration. So that is very important. So only on that presumption, you cannot tell that what this person is guilty or not. 10th question. Okay. The Pawan aims at Kamal but stabs Ajay instead. So I am aiming for Kamal, but by mistake I'm stabbing Ajay. Court says that intent travels, it's still a murder. So can that be classified as a murder? Yes. Under section 301 of the IPC, intention transfers. If A intends to kill B, so if A is trying to kill B, but by mistakenly he kills C, A is guilty of the murder. This is a doctrine of transmigration of the motive. So this is very important for exam perspective. Please do learn it. And the answer is what? Guilty under section 302 of the IPC. Intent transfers to C. So this is very important for exam perspective. Please do learn. Wishing you all the best. Good luck. This is me, Advocate Pawan, signing off. Take care. Goodbye. And for more details of the classes to everything, you can find below in the description box. Thank you so much. and even for the notes, if you want, you just need to access it. So thank you so much to the classes and all. So wishing you all the best. If you do like the video, please do like, share, subscribe. I say it always, even though it's recorded or not recorded, because when I take the class also, I just go tell it out in the class also. Please do like, share, subscribe. So that's in my blood now, because from very 2015 onwards, I'm starting my YouTube journey. That's why. So if you do like the video, please do let me know what are your views. Take care. Goodbye. This is me signing off.